All right. It is July 18, 2025. And welcome to Borderlines, Canadian Immigration Podcast. And we are joined today by Amandeep Hire and Lisa Middlemiss. Both have been
Again.
on the podcast before to discuss citizenship by descent. Welcome back.
Thank you.
Thanks. Yeah.
Amandeep and Lisa both wrote the book on citizenship by descent. If that's
Literally.
an accurate way to describe it.
Mhm.
They wrote the book, and when you were last on, we'll link to the show notes. We were discussing issues with citizenship by descent. There'd been an Ontario Superior Court of Justice decision that had struck down the previous law, and the Carney government has introduced legislation to amend Canada's citizenship by descent law. I kind of want this episode to be a standalone episode where I don't have to tell people go listen to the previous episode. So probably just ping pong questions off the two of you to get the audience up to speed on how citizenship by descent works in Canada. And why don't we start probably with the perfect intro question, which is, what does that even mean? Lisa, what is citizenship by descent?
So it is, what we have clients ask us: how do I get my citizenship? Well, some people may already be citizens through their bloodlines. It's basically a bloodline thing, whereby if an individual can trace trace themselves back to a citizen in their past, and they have proof of it. Most importantly, that they could be a citizen by descent. And over the years, Canada has gone through various iterations of who can qualify for citizenship by descent. And there have been some amendments to try to correct discrimination based on aspects such as gender and other factors. Right now, we're coming up to a pivotal piece of legislation, post-Bjorkquist decision, which could once again open up citizenship by descent to those born abroad beyond the first generation, who may have before been caught by that first generation limit.
Okay, there was a lot in there.
There sure was.
So maybe we'll pivot back to Amandeep with the limitation on citizenship by descent. So Lisa explained that, by descent means your parents kind of give it to you, regardless of where you're born. What was under the current law, before the current bill, what was the
Sure.
limitation on citizenship by descent?
So limited citizenship by descent, it depends on two factors. One, when you were born, and the law that was in place at the time, and the law that's in place today. Where it becomes a little confusing is, generally speaking, this is the rule. If you are born outside of Canada, if your parent was born in Canada or naturalized in Canada, there's probably about 90 to 95% probability that you're a Canadian citizen. Where it gets a little complicated is there's other people who do qualify for second generation exceptions. There's a really obvious one, which is anybody who's born outside of Canada, but was at the time their grandparent or their parent was in the service of the Crown. That would be sufficient to sort of overcome the first generation exception. If the grandparent had been the date that your parent was born, if it's a parent, it would be the date that you were born and they were serving the Crown. But where it gets a little complicated is this old act, and under those old acts, there were different rules in place. In particular, like the 77 Act, it allowed people to become citizens by descent in the second and multiple generations, so long as they made an application for retention by the 28th birthday. Under the 47 and the 52 Acts, you would be a citizen if your father was a Canadian citizen and your birth was registered within a specified time, which ended on, I believe, August 2004. Under the Old British Nationality Act, it's a little even more complicated because you have to look at the 47 Act as well. It's the Old British Nationality Act of 1814. There was also father, unless you're born out of wedlock, then it was your mother. So for the most part, I would just say that it's very complicated, but one of the issues that sort of keeps coming up is that issue of gender and marital status. It played such a huge role before 1977 And a number of people were sort of getting exceptions to the second generation limit because the first generation limit because they happen to be from one gender and marital status versus the other. And that's sort of been a ongoing issue in the Citizenship Act going back to basically when the charter was enacted.
Yep.
So I
So
don't
there's
really.
there's two types of lost Canadians. There's those who got lost trying to follow what you were just saying because citizenship is super complicated.
Exactly.
And then there are those who actually lost their citizenship because of all these little technicalities that you just mentioned.
Mhm.
And the big takeaway there again is that it is very, very complicated. Who qualified for citizenship by descent, who didn't. And maybe Lisa, back to you on the Bjorkquist, I think I pronounced that correctly, decision of, I can't remember if it's 2023 or 2024.
2023, but just almost into 2024. So yeah. And I was going to say, you're talking about lost Canadians, but there's also those who woke up Canadian, but we can maybe come back to them. But talking about the Bjorkquist, or I think everyone has a different version on how to pronounce it. The Bjorkquist case was a very important decision whereby it was a very sympathetic fact pattern. The families that brought the case, I think it was 7 different families, and a lot of them involved, a number of them involved cases where, parents were looking to claim citizenship for their children who've been born abroad beyond the first generation. And in a number of cases, there were applicants, women who had taken their careers abroad, in many cases had some substantial connection in one way or another to Canada. So they had, it was a sympathetic fact pattern, if you will. However, they had either, for example, they were either pregnant or had given birth abroad and couldn't necessarily come back to Canada to give birth to their child. And so under the old legislation, or the current legislation, really, until Bill C-3 becomes law, their kids wouldn't be Canadian. And it was just a great shock to the Ontario Superior Court when they went through the constitutional arguments, Section 15 in particular, and Section 6, basically because it came to be that these Canadians who had themselves been born abroad did not have the same rights as Canadians who were born in Canada. So this basically put a lens on the Citizenship Act in paragraph 33A, and which was considered unconstitutional. And then the government was basically sent back to the drawing board to try to come up with new legislation and deadlines to that effect, and had a first round at the new legislation with Bill C-71, which died on the books, if you will, before Parliament was prorogued last time around.
Yeah, I think that for me, the easy way to summarize it is that when somebody asks me, am I a citizen, I would find that I was going back to a piece of legislation, and then it required me to go back and do like historical research. What was the law at that time? We had this binder of all the previous copies of the act. I didn't know this, like it didn't exist in any other area of immigration. And then they kept trying to amend, but not writing the code in a new coherent way, but just making these tweaks. And always it seemed to create a new group that would still be impacted. And so we're kind of still in that state, are we not? Where there's no attempt to just write a clear code. It's still based on this kind of backward looking, like what was the law at that time and now new carve outs. Would you guys agree that that's kind of still where we're at?
Yeah, we're kind of still stuck in the mud, if you will. Kind of, there's still things to fix, and they're doing their best, and there's some elements that can correct it. But I guess it would be a huge undertaking, though, to totally rewrite the Citizenship Act, and there's a whole level of history behind it.
Well, why don't we get to then what is in Bill C-3? First, did any of you have experience with the citizenship by descent limitations? Like I can tell you the first time that I came across it was when a couple, both of whom were first generation citizenship by descent Canadians, were on holiday in Africa. The mother gave birth, they had a kid. The kid was impacted by the second generation limit. The family applied for a visitor visa so that they could return home from holiday, and the kid's TRV was denied on the basis that both parents were Canadian. And so it was unlikely that the baby would, on its own volition, I guess, be sent back by the parents without them. And we got, it was back in the day when you could more easily contact a visa office. And so we were basically able to just contact a program manager at the respective visa post and get the decision overturned. But that was my first, whoa, this law may have very unintended and bizarre consequences.
Yeah, I've had one like that. I've also had one where clients became permanent residents. Like it was a sponsorship application where dad was sponsoring the spouse. We tried to include the child because it was one of those situations where the law had changed. One of the kids qualified for second generation, but the other one didn't. I can't remember the specifics exactly. So we put the kid on to be sponsored along with his mom, and they said, I'm sorry, we can't grant this because we believe the child is already a Canadian citizen by descent. So we sent a citizenship certificate application and they refused it because they said he doesn't qualify. He needs to be sponsored. So the immigration department said he's like two different decisions that completely contradicted one another from the same from immigration. And so it's like they couldn't even tease out which rules should apply on the specific facts of the case. So so he was like, I don't know, like they couldn't even figure it out at the border. We don't know if you're a visit. Well, we'll just come on in. It doesn't matter. Like either way, we're going to let you in. But like he couldn't go to school because like he couldn't get the right status document. Like it was just it was just confusing.
I've had two like that. One was an individual who showed up at the border, U.S. citizen, tried to apply for a study permit, and it was a school that I work with very closely. And they reached out to me and said, hey, we just had this happen. Do you know anything about this? They would have let him in. They said, we can't give you a study permit. We think you're Canadian. Go talk to an immigration lawyer. So the school reached out to me and they said, well, let me see his documents. And we discovered, yeah, he's Canadian. You go ahead and study. Don't worry about it. You're fine. And we got him a proof of citizenship. The second one I had was like more fun. It was actually not my case. It was my father's case. He was representing somebody at the IAD for removal proceedings. So at the ID for removal proceedings, and he was arguing, well, he's Canadian, and I think CBSA, the officers argue, well, we have he's not Canadian until the certificate is issued. I'm like, and I wrote an opinion letter just saying, no, he's Canadian. Section 3(1)B says he is Canadian. And I remember the board member said, well, we can't just deport a Canadian. Let's wait for CPC Sydney to come back. And I think CBSA had argued, just send him back to Jamaica and they could sort it out there. It's like, no. CPC Sydney has to issue a decision first.
Yeah.
Oh,
And those certificates used to take like a year to be issued. I don't know what it's like now, but it's not like you could just, okay, well, then I'll just go to the passport office or something. You needed to get one document from immigration to present at the passport offices. So these are actual barriers that can, have impacts.
Actually, before we get into Bill C-3, there's also kind of this bizarre interim period for most of this year where it's been a little bit of a free-for-all in terms of like who can qualify for a discretionary grant of citizenship. Maybe Amandeep, instead of Bill C-3, why don't you describe like the free-for-all that this year has been in terms of who could be a citizen?
So it's been all over the place. Initially, when they started this, it was back last year. They sort of created a temporary policy. They said, if anyone has urgent need to be in the country, we'll process it as is. So at the time, I think I was taking a very cautious approach, but I think a lot of our colleagues were not. The approach I took was, okay, if you have an urgent need to be in the country, so it's a traditional, like you're looking for a job, you're moving up here, you need access to government services, we can do an urgent application with IRCC. The urgent application, the way it would work is it would basically say, well, we have an urgent need to be in the country, and without this proof of citizenship, we can't do it. So what they were doing is like, well, okay, if you qualify for an exception, like if you are restricted by the first generation, we will process the application as is. Now, one of the things that's happened is this bill has taken a very long time to pass. That ruling from the court came down December 19, 2023. We're almost halfway through 2025.
And that decision essentially said just that the bar for second generation born abroad was unconstitutional. That's like,
Mhm.
that's the decision, right?
Yeah.
But that led us
And
like to like a gap, like it's unconstitutional, but it's still the law.
yeah, and there's reasons for that. I mean, our courts are very cautious. I usually tell my American colleagues this, that unlike the courts down there, they usually don't step in. The general policy in Canada is Parliament passes laws. We can identify unconstitutional laws, whereas Parliament's job to change the law. So they very rarely actually fully strike down laws. They only do so where there's a real severe injustice or Parliament's just taking forever. And even if when there's severe injustice, they usually go for a very, very narrow ruling. They'll say, okay, in this individual case, we will not apply whatever it is that's preventing it, but Parliament fix it.
They also didn't appeal this for whatever, like,
Yeah.
Mhm.
And well, I think part of that's also because if we look at that historic issue, it was going to pop up at some point. Somebody
Yeah.
was going to say, look, I mean, I'm just being different. Like I had about at least 2 cases on my desk where I was saying like it was just the wrong parent, or
Right.
and just
I see,
certain
like a
things.
gender related difference. Had it been the dad who
Yeah.
was the person, it would have been okay, but because it was the mom that was the person that citizenship would have derived from, that was the showstopper, like
Yeah.
that.
Exactly, yeah, and we can go back to the bill. Why there hasn't been a lot of controversy about the retroactive application. I think part of the reason is because of how. I mean, it's just not defensible in the 21st century to say to women, "You aren't equal to men in terms of citizenship by descent."
Right.
But
And I'm
what's
going to do just
happened?
as a quick snapshot before you do Bill C-3, I had the ATIP of the current inventory of these types of discretionary citizenship grants as of April. And there
Interesting.
was, yeah, it was, now it's a bit, well, it was just 19,983 proof of citizenship applications were being processed, of which 1,655 were these first generation limits.
Oh wow.
And they were in
Oh,
the
wow.
process of determining that 773 qualified and 2 didn't. So I don't know what was up with the 2 that didn't. But that
Wow.
kind of is a sense of the numbers. And
Okay.
I think
And
going to
will
what
the-
Amandeep said in terms of like controversy, I think we'll get to this in a bit in terms of the bill, but I think part of the lack of controversy is it's just not clear how many people are
right.
impacted by this.
Right.
Mhm.
But
How
the
many have
first,
the motivation to really go for it too, to track back their citizenship several generations with ancestry.com and other,
right.
more original records?
But also like the
Um,
first order, I'm just like interested in the first order, what did the court say you have to do and in what time frame?
yeah, so the court said initially, I think they gave the government till June of 2024. And I remember because we were on the committee which for the CBA on this, and we were waiting up until May of 2024 to see, well, where is the bill?
Right.
And in May, they announced the bill, and they go back to the court. The court says, okay, you want an extension? We'll give you an extension for 1 month, but why didn't you introduce a bill sooner? And the government then, that's when the government came up with that urgent processing guidelines.
Right.
And they said, okay, we'll do this for anybody who's urgent, but yeah, we need more time to do consultations. This has major implications. So they got another extension to December 2024. And then around that time, one of the things that happened was politics. The Liberals, the popularity for the Liberals fell quite considerably. And what ended up happening after that was, well, there was a push for an election. And I don't think they passed any bills between then and the end of the year. And that was just one of the bills. And come November, the government said, look, we're in a minority government. We cannot seem to pass this bill.
And it was close too. It was like,
Yeah.
it was
Oh, yeah?
almost through. Yeah.
Yeah, it was
Huh.
almost through. I think if we had gotten up to second reading in the House, I think it got to first reading in the Senate because they were actually trying to do it concurrently and try to push it through.
I didn't know that. It just seems so strange because I wasn't following it that closely, but just seeing them like continuously have to go back to the court and say, sorry, we need
Yeah.
more time to comply
No,
with
there
the
was
court
nothing
order
getting
was
through, and then
super
Parliament
bizarre.
was prorogued.
Yeah.
Yeah, exactly.
Yeah.
And every
And
time they
then-
go back to the court, sort of reps on their knuckles and says, you're going to have to basically come up with a bit of a more fair interim measure too.
Yeah. Right.
And I think in the last court ruling, the court actually compared them to an 8-year-old who didn't do their homework for a year.
Yeah, that's fair.
Yeah, so
I mean, I'm
and
still
now,
surprised they didn't appeal it just to give them like time.
yeah,
If they were going to introduce this legislation anyways, and given the chaos
Yeah,
that
it
was
did
the
make them
last
look
government.
really foolish. Yeah.
yeah.
So what's in
Anyways,
Bill C-3?
well, before we go to Bill C-3, there is a new interim measure that he passed 2 months ago. And that new interim measure is anybody born before December 19th, 2023 can make an application, and at the discretion of the minister, they'll process it.
Yeah, just to
It's kind of,
use a term like past. You don't mean past Parliament. Just the minister announced by
yep.
posting on their website this new policy.
Yeah, the minister has authority in Section 5.4 to grant citizenship to anybody who makes an application. They said, we'll use this authority to process any application. The only restrictions are you can't have a criminal record. You must be willing to travel for a citizenship ceremony or attend a virtual ceremony and pledge allegiance to King Charles and his heirs and successors, first people of Canada, so on.
You need an oath, basically.
The oath of citizenship, yeah. Anyway, so Bill C-71, it died when Parliament was prorogued. Bill C-3 was introduced with only two major changes. Change number one, they removed reference to two corresponding bills, which I'm not sure why they're in there to begin with.
Interpretation Act related, right?
Yes, I think it was. And then
Right.
the other one, of course, is that it now references King Charles, Parliament assembling King Charles rather than Queen Elizabeth. So, yeah,
It's
the most
pretty
important
much.
that one.
Could we say it's almost like it's almost identical? It's very similar, anyways.
Yeah.
Right.
So, that's where things kind of stand at the moment.
So
Wow.
we're in an in-between, basically. You can wait or you can wing it under the interim measures. I get your application in there as a proof and then wait for a letter of exceptional grant, or maybe it'll take them so long to process these ones submitted under the updated interim measures without proof of urgency that these people basically are just going to be unprocessed, and then they'll finally in the end maybe be processed as a proof rather than a grant.
Right.
Exactly, yeah.
Right.
So that's where things somewhat stand right now.
And then going forward, it's also
that's where there is some controversy. So the issue is going forward, nobody's really dealing with the thing which is retroactive. So where they're fixing those retroactive gender discriminations, I think there's just a universal agreement across all five parties in the House that this has to pass. Where there is some controversy is how to move forward. What it says currently is this: you must have lived in Canada for 1,095 days before the birth of your child, which is actually almost consistent with what the US does. The US,
and that's for that we should maybe say that's for like once the Bill C-3 comes into force, that part.
Yeah.
Mm-hmm.
Now, it's 1,095 days, and that's using the same definition as it does for naturalization applications, which is 1,095 days of physical presence. That's where there is some controversy. The US does more or less the same thing. It's 5 years, and with at least 2 of those after your 14th birthday before the child is born. So you can see where they sort of were inspired by that. Where the controversy is, a lot of people are saying that's not enough. 1,095 days, I mean, basically by your third birthday, you'll hit that. However, what's the alternative? Now, one of the suggestions was made, it should be 1,095 consecutive days. That would limit things, I think, in my opinion, basically to no one. 1,095 consecutive days, one trip to Mexico.
I was going to say, thou shalt not go to Vegas.
Yeah.
And we live in the Lower Mainland. We're right on the border. We probably take it. I mean, until
Thou
about
shalt not save on gas.
recently, I would say there was at least one trip every other week to Washington to either go shopping or do something. Things have changed a bit for various reasons, but
yeah, but it also
very
gets kind of
typical.
complicated around like the charter guarantee to not limit people's mobility rights in order to be able to recognize like there's tension there.
Yeah.
So the new one I'm hearing is 1,095 days in the last 10 years before the child is born, which actually seems somewhat fair.
What's in the bill itself? I thought the
It's
bill just was any
1,095
time.
days over the period of a person's life.
Yeah. So
before
when
the
you say
child
that
is
the
born.
last thing you've heard is within the 10 years, where
Hmm.
is that just a rumor that they're going to amend the bill, or
That's one of the, I think CELA is pushing that amendment, I believe, when I last checked. And
CELA is pushing for it to be more restrictive? Interesting.
yeah, I was a bit surprised.
Mm.
And I think the Conservatives are
CELA, for those who
focusing
don't
on-
know, is the Canadian Immigration Lawyers Association.
Yeah.
Mm.
And then I've also heard that a few of the Conservative MPs, when they started realizing how restrictive it was, that it would be a problematic one, they're jumping on the 10-year. So that might
In a
be sort of
10-year
an-
period?
Yeah.
Huh.
So
And the interesting thing about this substantial connection test, because remember, Amandeep, when you were testifying in commission before Bill C-71, there was a discussion about the substantial connection test. And,
Mm.
you know, like, where does this really come from? Like, why is this required? And so that was kind of an interesting theoretical debate about, you know,
mhm.
like, what does this really give us? Like, what are they trying, I guess they're trying to show, you know, that all roads lead back to Canada. These are not just citizens of convenience. But the one official was even talking about, like, to try to avoid security concerns around citizenship, those who may be citizens, and not wanting to open it up too wide, and that almost suggesting that if some people have lived abroad for years, that they would be less or that they could have you know, developed other inclinations in terms of their allegiance in certain countries around the world. It was rather an interesting don't you find an interesting take?
Yeah, and I remember testifying, and I said this seems silly because the vast majority of the people are U.S. citizens,
Hmm.
and at least at the time, I was like, I don't think the U.S. is any real security threat to Canada. Um,
I
Again,
don't
things
know.
have changed.
Like, I'm
Well,
interested in what your views
Yeah.
are, what positions
Um,
you've taken publicly around what should
mm,
be the applicable standard.
I think, I mean, if I actually wrote an article about this for the CBA some time ago, and this is exactly what I suggested. I suggested something similar to the naturalization test moving forward. One of the things I sort of highlighted was I mean, the first generation limit, it came out of a very, very specific place. It came from the UK and Australia and New Zealand. They have similar first generation limits. But I mean, I pointed this out to in that article. Well, they're islands. They don't, I mean, you don't really have a large chunk of people, which just for various reasons, through of history, that are going to be born outside the island.
Mm.
And certainly you're not going to have people over multiple generations. It's going to be very rare. The only exception in Britain was Ireland. If you're born in Northern Ireland, you will be born so you could be born on the Republic of Ireland. But for the most part, again, there's the Irish, there's the Good Friday Agreement, as well as the Northern Ireland Protocol, which says anybody born anywhere in Ireland qualifies for British as well as Irish citizenship. So that's more or less solved. We have a very different situation in Canada. On both sides of the border, there are communities which the nearest hospital will likely be on the other side of the border. Here in BC is Point Roberts. If you are going to labor in Point Roberts, chances are you're either ending up at Richmond General, Surrey Memorial, or I forget the hospital's name, but it's in White Rock. You can end up in one of those three hospitals. And the reason for that is that's the closest place for the ambulance. There is no time to rush you to a hospital somewhere else in Washington. Similarly, there are places, for example, I believe it's Ellesmere in Manitoba. In an emergency, the Manitoba government has an agreement with North Dakota that the hospital where they'll be sent to is in North Dakota.
Mm-hmm.
Now, you can see multiple generations living in that same community. You're going to have somebody born in the second generation where the parents spent their whole life in Canada and they're not Canadian.
Mm.
So for me, I think there always needs to be something. Now, whether or not there should be an unlimited pathway, I mean, some countries have done that. Some countries have pure, sorry, I'm not even going to try the Latin, but pure bloodline citizenship, particularly in Europe. But most
Sui
countries,
generis, isn't that what? Yeah.
I'm not even going to try.
Yeah. Yeah.
So
It's hard though, right? Because like
yeah,
there's different like policy choices you can make, and you also have to be compliant with Bjorkquist as well, I guess, too, because the thing is, like, in a way you could say, in a sense, like from a personal point of view, I think maybe the second generation is actually the best place to sort of cut it off. And like pre-2009, there were some people who were eligible, not all, and born abroad in the second generation. But on the other hand, that could bring another constitutional challenge. And if you did the same thing with the third generation, maybe that as well. So I guess this is the legislature solution. And I do understand, I guess, that there's an interest in having some kind of nexus with Canada. And if we let this free for all, if you will, go on forever, it also is an administrative nightmare, I think, for processing these proof applications, because to try to trace back the bloodline, or through birth certificates, baptismal census records, naturalization in the US and other countries, it's a mess, let's say,
it's a complete mess. And now we look at the retroactive
two thoughts and
application.
a question that kind of ties both of these together. I mean, as far as like what the limit should be, I haven't probably put much as thought into it as you two have, especially because you two likely will be testifying before some level of government on this, having written the book. But like the first is, and I worked for the Conservatives at the time, was when the Israel Lebanon 2006, because you always need with those two countries which year you're talking about when they were at war, but 2006 war, when I can't remember if it was tens of thousands or hundreds of thousands of Canadian citizens had to be evacuated, and many of them had never been to Canada and had no ties to Canada, and the public was pretty annoyed at the cost of that. So there's the first issue of like, what obligations does Canada owe to people abroad who have never lived in Canada but are Canadian? The second, and probably the issue more for me, although again, I haven't put as much thought into either of this, is voting and the ability ever since the 2019 Frank decision. There used to be a law restricting Canadians overseas from voting, and the idea that there could be multiple generations of people who've never lived in Canada but are able to vote despite it not really impacting them is something that, without, I mean, I haven't put, again, a lot of thought into it, but something I'd be concerned about. The question that I have is, when they announced that they were going to basically try to resolve all the lost Canadian issues and looking backwards, grant citizenship of descent, an immigration consultant remarked to me that what we would see is a shift away from LMIA fraud to, hey, my great-great-great-great-great-grandfather, maybe not that many greats, but something, was a laborer born in Canada. Family went back to India. Here's a bunch of birth certificates that are fake. And I only use India because that was the example that the consultant gave, and that there's going to be rampant citizenship by descent fraud. Is that something that, what are your thoughts? Amandeep, you look a bit skeptical, but also positive.
Yeah. I mean, I'll be honest, I highly doubt it. Now, I mean, India is an interesting case. I'll tell you why. Up until 1947, everyone in India was a British subject, same in Canada. So if they had spent time in Canada, sure. But the one thing we do have good records of are immigration records. Going back to 1867, there are very good immigration records. What this country doesn't have, what this country out east doesn't have, the Albertan in me has to point that out, is birth records. So when you go look at Quebec didn't have a centralized birth registry until 1994. Ontario too, it was well into the 1900s. Nova Scotia didn't have centralized birth records until, I believe it's 1876, and then they stopped them for a while, and then they restarted them in the 1900s. So it is, I mean, it's a mess. That's where we're going to have some issues. I don't think we're going to have much sort of that kind of fraud, because even though there weren't any sort of centralized records, there were other records that the government accepts, and they're very, very specific. Generally, they want a birth record from the province. If you cannot get a birth record from the province, they will accept alternative evidence.
But they push back sometimes, we could say.
Yeah, they do push back. So what I've been using is census records. So if we can find census records which say, here is the census record from the government of Canada, which says I was born here, that's good enough. But you're going to need some sort of document at some point from the Canadian government, which the Canadian government will have in its own records.
Right.
So I don't
if
think
the person was really born there, we could say, right?
Yeah. I don't think it's going to be as big of an issue.
Yeah.
And then, again, to your point about Indians or anybody else from any part of the British Empire, they would have come in and they would have been landed.
Hmm.
So the 21 Immigration Act made a very strong distinction between those British subjects who were allowed to come to Canada and those who weren't. So,
Yeah.
people like me were not allowed to come in at that time. So,
Like me, I'm quite similar to where Steve's at in the sense that I haven't put a ton of thought into this, but of all the different controversies that are bubbling right now in Canada and globally, I think it just hasn't drawn the focus of my attention. But I think like from what you've discussed, it seems like to me they're looking for a very concrete kind of quantitative way of like drawing a line in the sand. But I think that it's especially difficult because of how complicated the historical approach to citizenship has been.
mhm.
That this is my kind of knee-jerk reaction, and I'm just interested in what your thoughts are on this because you have actually done the research and the deep thinking about it. Is that it seems to me that there's some flaw to just trying to come up with another formulaic, like this is the number, this is the test, rather than having a more, and I know Steve is going to get sick of hearing me say this, but there needs to be like a more qualitative approach
Mhm.
and the discretion to be able to look at what does substantial connection mean? Something kind of more akin to like what we do under the Ribbick like analysis for permanent residency. Like, here are the factors that a decision maker needs to look at. Like, what does, not just like this number of days, because if you were forced to leave because of some specific thing, but there was always a substantial tie and intent to return, like anything like that, like can't we just set out the factors in the legislation and leave an adjudicator who will develop expertise in this to consider those? Apply
That's
them to the facts
cuckoo
of the
like
case.
the coup test. So the coup test, for those
Sure.
who don't know, it used to be a test prior to 2014 where the test for citizenship required, I believe at the time it was 3 years out of 4
Mhm.
of residence in Canada, and residence was interpreted different by different decision makers. And one of the tests that was sort of qualitative was the coup test, and they did away with it just because it was a bit of a gong show. Like the decision maker could choose which tests to decide, and
That was
then
the problem.
different
It wasn't
judges.
that the coup test was wrong. It's that half of the judges decided to not really do it and just insist on physical presence.
Well,
And
no, the
so,
judges decided that the individual like the individual citizenship officer could decide which test to do.
yeah, but that's weird.
Yeah.
That's weird
I
that
mean,
you
the thing with like
choose
is
to
you
follow
just
these
get the weird
rules.
outliers, right? Where someone who had almost no
Yeah.
presence in Canada, it became very unpredictable with applications, like throwing darts at a dartboard and just seeing what you get. So I'm not saying there's no merit to coup. I can see why they wanted to move away from it. But it does raise problems, like you said.
Yeah.
Yeah.
Personally, I don't know. I think like this a clear, very easy to understand bright line test is the best approach
Really, yeah.
because
Can you
I
just say
mean
why?
I'm sick and tired of reading the Citizenship Act, to be honest.
Yeah, I get it.
Like every time it's like, okay, does this apply? I think I've spent about an hour with another lawyer yesterday going, yeah, I think this section, which I've been interpreting one way, I could interpret it the other way. And
Totally.
Mhm.
And
it's
you've been
it's
doing
getting to be too
more,
much.
like the two of you have been doing
Yeah.
more of these deep because we all just, when it's a real complicated one, I just call one of the two of you and be like, help. So, like, if you're still flip-flopping about how this can be interpreted, it's a problem.
Yeah, and I think, I mean, in this particular area, and something we said in the book, I mean, what we're saying is citizenship law is sort of unique in that what it says is that we are a people and this is who we are. People should not have to have a law degree to look at the act and go, yeah, I'm Canadian.
Yeah.
It should be
Or
very
not.
simple.
Yeah. I'm Canadian
Yeah,
or
Yeah,
am I not? Yeah.
yeah,
totally.
and we've had so many issues over in the past. I mean, the
Yeah,
issue of the lost Canadians is because, oh, we're going to throw all these other values into it. Well,
right, right. I totally
those
see that.
values change over time, right? So,
Yes, and how do you actually discern somebody's values in the scope of an application? And no, I totally hear what you're saying. I just remember there was a brief moment when they put up one of those citizenship eligibility wizards on the IRCC website. Do you guys remember this? And I was like,
Yes.
oh, thank God, I don't have to keep reading the Citizenship Act. And then they had to take it down. And like every time I put in my fact pattern, the answer was, you may or may not be a Canadian citizen. And I was like, this is the most unhelpful tool.
But
that's it. They couldn't. The wizard couldn't even do it.
No, it's like it wasn't an algorithm that could be sorted through, and so.
But that's what they're looking for. That's the thing. That's, that's what I find so fascinating is, I think there is this desire for like these, hard and fast sorts of algorithms and whatnot at IRCC. And so I think, maybe that's where there leads them to certain rules, like, 1,095 days instead of more of a substantive test.
What do you think, Lisa? Like, I got Amandeep's read on how he would like to see. He wants a binary answer. What about you? Are you in the same camp?
I know I like your camp, but I don't think that's the way that the department has been moving. Like, they're really moving into the more automation, like do it yourself mentality. Like, we see it even with the fact that, you can't file citizenship applications as lawyers for your clients through the online portal, that it's only still several years after its inception accessible to individual applicants. So they make it look easy, right? Like anyone can do it, just put your citizenship application in. However, as people find out sometimes when they get letters along the way, or rejections or refusals, that actually does oftentimes help to seek legal counsel.
Right.
Yeah.
I have a question. Sorry, I'm sorry, Steve. I need to get this one. Which is that when the people right now who are getting the interim decisions and that are being granted through a grant versus those who would ultimately be issued citizen, like who will be confirmed as permanent residents through a proof process, is there going to be, that you can think of, a substantial difference for those?
I don't think so, because the Director General Citizenship at IRCC mentioned at the conference in Victoria, basically that those who have been granted citizenship under the exceptional measures under 5.4, once Bill C-3 passes, would then nonetheless still be citizens by descent. So I don't think there's any, from what I can gather, I don't think that there's any kind of like downside to being granted yet. Although there may still be some instances where, it would be better to be granted, or I mean, to be, to have proof from the outset instead of granted. But I can't really find any flagrant downsides.
Right. There's just going to have to be another carve out in future things. If you happen to get a grant between this period and this period, you're going to be treated as if you had proof.
No, so the bill, what it says, is just going to retroactively cancel all of them. It's also going to apply. I mean, I'm actually representing somebody right now with the permanent, like two people who I helped them get the permanent residency. And I was like, hey, all that work we did, all that money we built, you're retroactively going to become Canadian from birth.
No, you don't have to wait your 1,095 days.
Yeah, and it's that's just what's going to happen.
That's how you spin it as a good story.
Just looking at the time left. Looking at the time left, we have two questions that are both really good that have come in. The first is, if I don't have proof through birth certificates, can I use websites like 23andMe or Ancestry to prove that I am Canadian? I think, Amandeep, you talked about this at CBA. And there's another question that's really good also, and we just have a few minutes left, so maybe in like a minute.
Ancestry is a great source, but only if you can get government documents. So the way I do is this. One, we apply for the Nova Scotia birth records. Or I'm thinking Nova Scotia.
Provincial.
Provincial birth records. If we can get the provincial birth records, great. That's what we're going to use. Generally speaking, any problem with Western Manitoba, we're going to get it very quickly.
Right.
Okay. If we can't get that, next one is, do we have any other Canadian government records? That could be baptismal certificates. They were treated equal to birth records, particularly in Quebec, up until basically the mid-century. And then the third thing we look at is, well, what is your other government have, which is usually the U.S. government. The U.S. government had great records. You can usually find stuff going all the way back to the 1800s. Typically, you'll get a sworn statement from the U.S. Naturalization Office saying, "Hey, I naturalized and I was born here." So those are the three things.
Right.
I don't think 23andMe is going to work because I've actually heard it's not accurate at all.
Well, it's self-reporting, I think, for the most
Yeah.
part, right? It's not
And
based on
then
DNA or
you can
whatever.
add another problem there, which is, well, unless you're First Nations, we're a settler country.
Ah,
Mm.
You're going to be
that
traced back
brings
to Europe
me to the second
or
question, which is
Eurasia, I
from
should
an
say.
immigration consultant. Sorry to interrupt. I'm just looking at time left, and this is a really good question. So it's from an immigration consultant on Instagram. Hey everyone, wondering if you have ever ran across this situation. I had someone approach me who was looking to apply for citizenship. She's a member of a Native American nation in Canada. Her grandmother was displaced to America during the forced movement of her nation. Her father was born in America and so was she. With the new regulations laws, do people like this have any chance of a special grant of citizenship, citizenship by descent? Do the new regulation laws mention anything about displaced Native Americans?
I
That's a
just
great
had one
question.
today.
Yeah, I've done a lot of like
Yeah.
this types of, but it's again, it's there. Yeah. Anyways, I'm gonna leave it to Amandeep to answer.
Yeah. I just had one the other day where we were able to. So now we're just sort of getting all the records in place. But yeah, I think that's a good one. The other thing to keep in
Under
mind there
the
is
interim
also,
measures, though, would you say? I would say under the interim measures is a good time before Bill C-3.
yeah, and I think
Why,
this one here
why
is
would
the
it be
problem.
different under Bill C-3?
I don't think
Well,
there's
you never know what
any.
Bill C-3 will look like in the end.
That's fair.
So I'm
Yeah.
telling people if you qualify in the interim measures, just go.
Yeah.
But the other one to keep in mind there is the Indian Act. See if they qualify there too. That might be a better starting point.
Yeah, a lot of people like it's a question even whether or not they would want Canadian citizenship or just recognition of inherent rights. So,
Mhm.
like
Do you want to elaborate on what that means?
well, I mean a lot of a lot of people don't wish to like they don't wish to have their entitlement to be on um like unceded territory or on lands that are actually ancestral. There's some ancestral connection to being conferred under a piece of Canadian citizenship legislation. And so, I mean, that doesn't necessarily mean they want it conferred by the Indian Act either. But again, so it's like, I think in managing these types of consultations, it's whether or not they want to find a solution that emanates from inherent rights or I think that there's a very interesting area of intersectionality between citizenship law, Indian Act, colonization, what the impact was of forced displacement
I
by
agree.
settlements,
Oh,
and
we've been
like
talking about doing an episode on this
yeah,
for
I really,
a
really want
decade.
to. Yeah, I know. It's really true. And it's super, super, there's a lot to unpack in there. But like we were even talking about this in terms of proposing amendments to the IRPA. Like, what is the place of the IRPA in saying, well, First Nations people can enter and remain? Like
Mhm.
it's kind of odd, right?
Yeah.
Like they're certainly
Yeah.
not like it's yeah. So it's again, there's a lot to this kind of question. But I think something like when you're discussing about right to be here, not just as like somebody who can come in, but somebody who actually has a right to be here with all of the same like original, you know,
Yeah.
abilities to do whatever they wish to be like. Is it something that has to be conferred on them by the Canadian government? It's like it's a larger question.
True.
Correct me if I'm wrong, but if you're recognized by the Bureau of Indian Affairs in the U.S., my understanding is you're basically allowed to we're recognized by the Indian Act in Canada.
No, not at all. I think that that's the problem. A lot of people because Canada doesn't recognize the Jay Treaty, and they
Mhm.
say that the Jay Treaty, which was the one that was supposed to like enable mobility, that the Jay Treaty was signed by the British and not by Canada. And so there's not that reciprocity. That's true if you're going from Canada into the United States, but it's not reciprocated on the Canadian side. And so, but also not like getting registered under the Indian Act is complicated, especially for specific Indigenous groups. And so, but Canada border agents are informed by the IRPA, which says you need to be registered under the Act. Otherwise, like there's a lot of complexity about who'll be recognized. So
Yeah, there's a public policy for I think work permit exemptions, Amandeep, that's broader, but this has to be for our episode that we'll do maybe a decade from now, because we keep talking about it. But if anyone's listening who is an expert on
I know experts on
Indigenous,
this who should definitely be our guests. So yeah.
Hopefully in the next decade. One of the things we want to start doing better, because everybody keeps telling us we need to do better, is Amandeep and Lisa, where can people find you?
Oh.
We'll just go Amandeep and then Lisa, or either order.
Lisa, you can go first.
You mean like find
Email,
me, track me
Twitter,
down?
LinkedIn,
yes.
You down.
Website, Twitter, and LinkedIn.
Is there just Lisa at Lisa Middlemiss?
Yes, pretty much. I guess I should have my my tags handy, but yes, it's I can pop it in the chat, for example.
Yeah, we'll put it in the show notes. But yeah, we've been told to start asking the guests to say how they can be contacted at the end.
Nice, thank you.
Yeah.
Thanks again for the invite.
Yeah, Amandeep.
So my first name at hairlawoffice.ca, or you can visit my website, which is the preferred method. There's a contact us page, and it goes straight to my email as well as my assistant's emails.
Awesome. Thanks for coming on again.
Yeah, super interesting.
Thanks again.
Okay. Bye.